एन कोटेश्वर सिंह सर, जज सुप्रीम कोर्ट ऑफ इंडिया का बहुत बहुत स्वागत। ऑनरेबल मिस्टर जस्टिस जॉय माल्या बागची सर का भी बहुत बहुत स्वागत। ऑनरेबल मिसेस जस्टिस मीनाक्षी मैडम, मीनाक्षी मदन राय, ऑनरेबल द चीफ जस्टिस पटना हाई कोर्ट का भी बहुत बहुत स्वागत। ऑनरेबल मिस्टर जस्टिस राजीव रंजन प्रसाद सर का बहुत बहुत स्वागत। मंच पर मुख्य सचिव बिहार आदरणीय श्री प्रत्यय सर का बहुत बहुत स्वागत। साथ ही हम स्वागत करेंगे एडवोकेट जनरल बिहार श्री सत्यदर्शी संजय सर का बहुत बहुत स्वागत। हम स्वागत करेंगे डॉक्टर बी राजेंद्र सर, डायरेक्टर जनरल विपाड। साथ ही हम स्वागत करेंगे श्री कुंदन कुमार, सचिव गृह विभाग का बहुत बहुत स्वागत करते हुए हम सभी अवगत कि भारत की संस्कृति में प्रत्येक शुभ कार्य राष्ट्र के प्रति समर्पण से प्रारंभ होता है। आप सभी से विनम्रता पूर्वक अनुरोध करूंगी कि राष्ट्रगीत के सम्मान में अपने स्थान पर खड़े हो जाएं। शिव गोपाल मिश्रा जी को मंच पर मैं आमंत्रित करूंगी। ऑनरेबल मिस्टर जस्टिस एन कोटेश्वर सिंह, जज सुप्रीम कोर्ट ऑफ इंडिया को सम्मानित करने हेतु। बुद्ध की यह नगरी हरित स्वागत और साथ ही अंगवस्त्रम बहुत बहुत धन्यवाद करते हुए अब मैं डायरेक्टर बिहार जुडिशियल एकेडमी आदरणीय श्री भारत भूषण भसीन सर को मंच पर आमंत्रित करूंगी। ऑनरेबल मिस्टर जस्टिस जॉय माल्या बागची सर, जो कि जज सुप्रीम कोर्ट ऑफ इंडिया, उन्हें सम्मानित करने के लिए। धन्यवाद सर। अब मैं श्री प्रदीप कुमार मलिक, जो कि प्रिंसिपल डिस्ट्रिक्ट सेशन जज गया है, आपको मंच पर आमंत्रित करूंगी। ऑनरेबल मिसेस जस्टिस मीनाक्षी मदन राय, जो कि ऑनरेबल द चीफ जस्टिस पटना हाई कोर्ट है, उन्हें सम्मानित करने और उनका स्वागत करने हेतु आप सभी से आग्रह है, करताल ध्वनि से स्वागत करें। मंच पर आमंत्रित करूंगी श्री सुभाष चंद्र शर्मा जी, जो कि डायरेक्टर एडमिनिस्ट्रेशन बिहार जुडिशियल एकेडमी है। ऑनरेबल मिस्टर जस्टिस राजीव रंजन प्रसाद, JED2 पटना हाई कोर्ट कम चेयरमैन बिहार जुडिशियल एकेडमी को सम्मानित करने हेतु। करताल ध्वनि से आप सभी स्वागत करें सम्मानित मंच का। कमिश्नर मगध प्रमंडल मैडम डॉक्टर सफीना AN से विनम्रता पूर्वक आग्रह करूंगी मंच पर आसीन आदरणीय मुख्य सचिव बिहार श्री प्रत्यय अमृतसर का हरित स्वागत, स्नेह वंदन, हार्दिक अभिनंदन। श्री निशिकांत ठाकुर सर, एडिशनल डायरेक्टर बिहार जुडिशियल एकेडमी को मंच पर मैं आमंत्रित करूंगी। श्री सत्यदर्शी संजय सर को सम्मानित करने हेतु आप एडवोकेट जनरल बिहार हैं। करताल ध्वनि से आप सभी स्वागत करें। अब मैं मंच पर आमंत्रित करूंगी मिस पल्लवी आनंद जी को, जो कि एडमिनिस्ट्रेटिव ऑफिसर बिहार जुडिशियल एकेडमी है। मंच पर डॉक्टर बी राजेंद्र सर, जो कि डायरेक्टर जनरल विपाड, उन्हें सम्मानित करें। बहुत बहुत आभार आपका। मैं मंच पर आमंत्रित करूंगी श्री मुकेश कुमार जी, जो कि डिप्टी डायरेक्टर बिहार जुडिशियल एकेडमी है। आदरणीय सचिव गृह विभाग बिहार श्री कुंदन कुमार जी को सम्मानित एवं उनका स्नेहवंदन हार्दिक स्वागत करने की असीम कृपा। सम्मानित मंच का बहुत बहुत स्वागत करते हुए कार्यक्रम को आगे बढ़ाते हुए अब मैं सम्मानित मंच से माननीय मुख्यमंत्री महोदय से, न्यायमूर्ति गण से, आप सभी से विनम्रता पूर्वक आग्रह करूंगी दीप प्रज्वलन कर कार्यक्रम का विधिवत शुभारंभ करने की असीम कृपा करें। 2 दिवसीय राज्य स्तरीय परामर्श का शुभारंभ दीप प्रज्वलन के साथ माननीय मुख्यमंत्री महोदय, न्यायमूर्ति गण, आप सभी सम्मानित अतिथिगण से आग्रह। दीप केवल प्रकाश का प्रतीक नहीं बल्कि ज्ञान, न्याय और सत्य, मानवता की विजय का प्रतीक है। जहां दीप प्रज्वलित होता है वहां अज्ञान का अंधकार स्वयं समाप्त हो जाता है। दीप ज्योति परम ज्योति, दीप ज्योति जनार्दना, दीपो हर्तु मे पापम, दीप ज्योति नमोस्तुते, शुभम करोति कल्याणम, आरोग्यम सुख संपदाम, दोष बुद्धि विनाशाय, आत्म ज्योति नमोस्तुते, आत्म ज्योति प्रदीप्ताय, गुरु ज्योति नमोस्तुते, गुरु ज्योति प्रदीप्ताय, ब्रह्म ज्योति नमोस्तुते, ब्रह्म ज्योति नमोस्तुते। बहुत बहुत आभार प्रकट करते हुए हम सभी अवगत हैं कि स्वागत केवल औपचारिकता नहीं बल्कि आत्मीयता का प्रथम परिचय है। अब मैं आदरणीय डॉक्टर बी राजेंद्र सर, जो कि महानिदेशक विपाट है, आपसे विनम्रता पूर्वक आग्रह करूंगी कृपया स्वागत संबोधन हेतु पधारे।
Honorable Chief Minister Bihar Sri Samrat Chaudhary ji, Honorable Mr. Justice N. Koteshwar Singh, Judge Supreme Court of India, Honorable Mr. Justice Jaimala Bagchi, Judge Supreme Court of India, Honorable Mr. Justice Meenakshi Madan Rai, Chief Justice High Court of Judicature at Patna, come Patron-in-Chief Bihar Judicial Academy, Honorable Mr. Justice Rajiv Ranjan Prasad, Judge Patna High Court, come the Chairman Bihar Judicial Academy, Honorable Judges of the High Court of Judicature at Patna, Chief Secretary Sri Prati Amrit ji, Learned Advocate General Bihar Sri S.D. Sanjay ji, Home Secretary Bihar Sri Kundan Kumar ji, Additional Chief Secretaries, Principal Secretaries, Secretaries of various government departments, Principal District and Session Judges and other judicial officers, District Magistrates, DIGs, IGs, Divisional Commissions connected through video conference, SSPs, SPs of all districts, distinguished members of judiciary, senior officers of Government of Bihar, members of police, prosecution, forensic science, and prison administration, distinguished delegates, ladies and gentlemen. A very warm good morning to all of you. It is my privilege and profound honor on behalf of Bihar Institute of Public Administration and Rural Development, and in close collaboration with Bihar Judicial Academy, to extend a very warm and heartfelt welcome to all of you to this 2-day state-level conference on the unified implementation of new criminal laws. We are deeply honored by the gracious presence of Honorable Chief Minister of Bihar. Sir, despite your extremely demanding schedule, your presence today is a testimony to Government of Bihar's unwavering commitment to strengthening the rule of law, ensuring timely justice and facilitating the effective implementation of Bharatiya Nyaya Sanhita, Bharatiya Nagarik Suraksha Sanhita, and Bharatiya Sakshya Adhiniyam. Your visionary leadership continues to inspire all institutions engaged in the administration of justice and public governance. It is a matter of immense pride and privilege to all of us that this conference is being graced by 2 honorable judges of Supreme Court of India. I extend my respectful welcome to Honorable Mr. Justice N. Koteshwar Singh, Judge Supreme Court of India. Your Lordship's gracious presence greatly enriches this conference, and we are deeply honored by your participation and guidance. I extend my most respectful and cordial welcome to Honorable Mr. Justice Jaimala Bagchi, Judge Supreme Court of India, whose distinguished judicial career and profound contribution to the development of criminal jurisprudence have earned admiration across the nation. It is our great privilege to welcome Honorable Ms. Justice Meenakshi Madan Rai, Chief Justice of High Court of Judicature at Patna. Madam, your inspiring leadership of the constitutional institution entrusted with the administration of justice in the state is constant source of encouragement for all the stakeholders committed to judicial excellence. I extend my respectful welcome to Honorable Mr. Justice Rajiv Ranjan Prasad, Chairman Bihar Judicial Academy. Sir, this conference has been conceived and organized through the close partnership between the Bihar Judicial Academy and BIPAD. Your vision, encouragement, and personal guidance have been instrumental in transforming this initiative into a significant platform for institutional dialogue and capacity building. I also have the distinct honor of extending my respectful welcome to the Honorable Judges of the High Court of Judicature at Patna, who have graciously agreed to chair and guide the technical sessions during the course of this conference. Your Lordships, your gracious acceptance to lead the technical deliberations over the next 2 days is a matter of immense privilege for all of us. Your vast judicial experience, legal scholarship, and practical wisdom will undoubtedly enrich our discussions and provide invaluable guidance for the effective, uniform, and citizen-centric implementation of these transformative legislations. I extend my respectful welcome to the Chief Secretary, Sri Pratyamrit Ji, Learned Advocate General, Bihar, Sri S.D. Sanjay Ji, Additional Chief Secretaries, Principal Secretaries of various departments, Sri Kundan Kumar, Home Secretary, Bihar, whose wholehearted support have been pivotal in strengthening the state's preparedness for implementing these transformative legislations. I extend my heartfelt welcome to all principal district and session judges, judicial officers, SSPs, SPs, prosecutors, forensic experts, prison administrators, academicians, resource persons, and delegates who have traveled from across India to participate in this important conference. In addition to it, I also welcome district magistrates, DIGs, IGs, divisional commissioners connected through video conference. Distinguished ladies and gentlemen, the enactment of Bharatiya Nyaya Sanhita, Bharatiya Nagarik Suraksha Sanhita, Bharatiya Saksh Adhiniyam represents the most comprehensive reforms of India's criminal justice system in the recent decades. These legislations seek to replace colonial legal frameworks with a justice delivery system that is modern, efficient, technology-driven, transparent, and deeply sensitive to the rights of victims and the expectations of the society. However, the true success of these laws lies not merely on legislative reforms, but in effective implementation. This requires seamless coordination among the judiciary, police, prosecution, forensic science, institutions, correctional administration, and every stakeholder in the criminal justice system. Before I conclude, I express my sincere gratitude to all my colleagues in BIPAD, led by Dr. Safina A.N., ADG BIPAD, Bihar Judicial Academy, the Home Department, the Department of Social Welfare, Police Headquarters, the District Administration led by District Magistrate and SSP Gaya, and every officer, institution, and member of the organizing team whose tireless efforts have made this conference possible. Once again, I extend my heartfelt welcome to all our distinguished guests and participants. I wish this conference highly productive deliberations and every success. Thank you. Jai Hind.
स्वागत संबोधन हेतु सर का आभार प्रकट करते हुए अब मैं गृह विभाग के सचिव आदरणीय श्री कुंदन कुमार सर से विनम्रतापूर्वक आग्रह करूंगी उद्बोधन हेतु पधारे.
Chief guest of this conference, Honorable Chief Minister of Bihar, Sri Samrat Chaudhary Ji, Honorable Mr. Justice N. Koteshwar Singh, Honorable Mr. Justice Joy Mala Bagchi, Judges of the Supreme Court of India, Honorable Chief Justice Meenakshi Madan Rai, Honorable Justice Rajiv Ranjan Prasad, Honorable Judges present here of the Patna High Court, Sri Pratyamrit, Chief Secretary Government of Bihar, Sri S.D. Sanjay Ji, Advocate General Bihar, Sri B. Rajender, Director General BIPAD, distinguished judicial officers, senior police and prosecution officers, legal scholars, colleagues from the administration, distinguished guests, ladies and gentlemen, a very good morning to all of you. It's a privilege to welcome all of you to this important conference on unified implementation of new criminal laws. But before I begin, I will like to compliment the relentless effort of Honorable Justice Rajiv Ranjan Prasad sir, and our DG Bipard and their team, whose relentless effort is why this conference was able to be put up here. It's a gathering of people who need not be told what BNS, BNSS, and BSA is all about. You know these laws, and many of you know them better than most of us. So I do not intend to stand here and read out provisions of these statutes before the audience. What I do want to do is to share how at Home Department we look at these statutes and their implementation. My compliments first of all to all the stakeholders, because of whose efforts Bihar has done very well, and it is under the chairmanship of our and leadership of our Honorable Chief Minister that Bihar has done really well in terms of implementation of these laws. And it is the Union Home Ministry which primarily oversee the implementation of these laws, the new criminal laws. And I would be very happy to tell all of you and inform this August gathering that the 5 core pillars of ICGS 2.0, Bihar has been able to implement it, and we are relentlessly pursuing the seamless integration of the same. It is through these integration that the numbers which reflect on the portal on which the state is ranked, and we are ranked almost like we are ranked 17th across all Indian states. This is a relentless pursuit of all stakeholders, and we are doing the same. Let me first tell you that the 5 core pillars, which is e-court, e-prison, e-jail, and e-FIR, we have, all the portals are running pretty well. What we need to do is the seamless integration. If this integration is not done, the numbers, the figures will not appear. So the good work that we are all doing here is not reflected at the national level. So maybe during the 2 days conference, what we can reflect upon is the issue of technology that we all are facing, and how we can challenge, how we can redress this technology issue, and a bit of lack of awareness, how we can increase this lack of awareness, how we can redress this lack of awareness to further build on the good work that we are doing. Let me also tell you that 3 laws which came into effect in July 2024, 2 years have now passed, and if I were to describe the 2 years that have passed, I would say a steep and necessary learning curve for all the 3 pillars, that is police, prosecution, and for the courts as well. Through these 3 laws, what we have witnessed is the changes which are not cosmetics. The BNSS for the first time makes forensic examination of crime scenes mandatory for offences carrying 7 years or more of imprisonment. Charge sheets have prescribed timelines. Trials for heinous offences are expected to conclude within defined periods. 0 FIR, e-FIR, and supply of FIR copies to complainants within 24 hours are not just aspirational provisions, they are legal obligations. It is where I see the 3 things that we urgently need to do. The first is the need to bring better coordination among the 3 pillars, that is police, prosecution, and judiciary. We have always functioned as 3 separate institutions with 3 separate chain of commands. 3 new laws, however, are built on the assumption that we function as one continuous system. A charge sheet filed late does not just delay a trial, it breaks a statutory guarantee. An investigating officer who's unfamiliar with the new evidentiary requirements under the BSA does not just make a procedural error, he potentially compromises on the entire case. The coordination that these laws demand is not optional. it has to be built deliberately. And I'm happy to tell you that in Bihar, we have already begun. District Prosecution Directorate are being established in every district as mandated under the BNSS to ensure that the investigating officer and the prosecutors are aligned from the very first day of a case, not just at the stage of trial. This conference is step in exactly the same direction at a higher level. The second challenge is that of technology and infrastructure. The Bharatiya Sakshi Adhiniyam has given full statutory recognition to electronic records and digital evidence. Tools like e-Sakshi, e-Summons, Nyay Shruti, and the case information system are now part of the legal architecture, and these are not just pilot projects, not just future plans. In Bihar, we have tried to match that statutory intent with ground-level action. I am again happy to inform you that under the leadership of our Honorable Chief Minister, we have been able to provide laptops to every investigating officer and every prosecution officer so that they can handle electronic records and digital evidence effectively. CCTNS has been implemented in 968 police stations out of 1,382. This is a work in progress. The moment we cover all the police stations, our figures will definitely increase. Let me also tell you that on forensic front, what we have done is we have collected forensic evidences from 26,000 crime scenes, and we have been able to do this with 51 mobile forensic vans deployed across the state. The system that works in Patna must work equally well in Araria, Jamui, Kamur, Kishanganj. What I mean to say that it has to be uniform, and that is what exactly at Home Department we are trying to do. Ladies and gentlemen, the third issue, the third challenge is to create awareness and to change the mindset. Training can be mandated, circulars can be issued. Out of the 65 notification, government orders, standing operating procedures, and resolution required for implementing the new criminal laws, Bihar has already issued 61. So there are only 4 which are left. The administrative groundwork is largely in place, but the real change happens when an investigating officer genuinely understands why the new law requires what it requires. When a prosecutor approaches the new framework not as a burden, but as a better tool, when a trial court sees their statutory timelines not as a pressure, but as a promise to the victim. This change cannot come through circulars, notification, or training sessions alone. It requires a gradual shift in professional culture, a shared understanding that these reforms are intended not merely to change procedure, but to improve outcomes. That is why a conference such as this is particularly valuable. It allows judges, police officers, prosecutors, and administrators to come together, exchange experience, identify practical challenges, and build a common understanding of what effective implementation should look like. Ultimately, the success of the new criminal laws will depend not only on the text of the statutes, but on the collective commitment of all stakeholders to make them work in practice. The Home Department is committing on doing its part. We will provide the resources, the infrastructure, and the policy support that is needed. But we need the feedback, the ground-level experience, and the judicial guidance that only a gathering like this can produce. I look forward to the next 2 days of deliberations, and I am confident that what comes out of this conference will be concrete, actionable, and genuinely useful to the people of Bihar. I thank BIPART and the Bihar Judicial Academy for bringing us all together here in Bodh Gaya. Jai Hind.
सर का बहुत बहुत आभार प्रकट करते हुए अब मैं बिहार के महाधिवक्ता श्री सत्यदर्शी संजय सर से अनुरोध करती हूं कि अपने विचारों से इस परामर्श को और समृद्ध करने की कृपा करें.
Honorable Chief Minister Bihar, Honorable Justice N. Koteshwar Singh, Judge Supreme Court, Honorable Mr. Justice Joymalia Bagchi, Honorable Judge Supreme Court, Honorable Chief Justice Patna High Court, Justice Meenakshi Madan Roy, Chief Justice, Honorable Justice Rajiv Ranjan Prasad, other honorable judges sitting in this auditorium, the Chief Secretary Bihar, the Home Secretary Bihar, the Chairman Bipard. Today, in this pious city of Gayaji, we have all assembled to deliberate on the 3 new Criminal Procedure Code, Evidence Act, and the Penal Code. In this deliberation, we will be discussing number of reforms approach to take out the criminal justice system from the colonial system, and various new laws have been introduced. Further, for technical investigation and digital investigation, lot of provisions have been incorporated. Now, those deliberations will be made by the speakers. I want to speak some other things also in this August gathering, as our Honorable Chief Minister is here, Honorable Judges of the Supreme Court, and particularly Honorable Justice Joymalia Bagchi, who will be in future, who is going to be the Collegium Judge and the Chief Justice, and Honorable Justice Koteshwar Singh. So, I would like to flag certain issues which will be very fruitful for us in course of time. At the outset, first, you all know that I have been just appointed as Advocate General, as prior to this, I have been doing my assignment as Additional Solicitor General of India in the Supreme Court. And I thank to the Honorable Chief Minister for having reposed so much of trust in me, that in spite of the fact that I had requested him to please spare me in Delhi, I was very happy doing my work in Delhi in my assignment. He said, no, we have trust in you and we want you to return back to Bihar. And therefore, in order to serve my state and to become a bridge between the Honorable High Court, Judiciary and the government, I decided to come back to Bihar and serve Bihar. So I again thank for reposing confidence in me. Now, another aspect, I further thanks to Honorable Judges of the Honorable Supreme Court and Honorable Justice Joymalia Bagchi. Now, let me tell you, there is a case which is being monitored by the Honorable Supreme Court for establishment of special exclusive court for trial of heinous offences. Now, the bench of Honorable the Chief Justice and Honorable Justice Bagchi are monitoring, and all the states of the country are party in that, and even their lordships have called the Advocate Generals. Now, for the purpose of speedy disposal of serious offence cases. Now, the concern of the Supreme Court was that because of the delay in the trial of those cases, the Supreme Court or even the High Court at times are constrained to grant bail even to those accused against whom serious allegations have been made. But then the period of incarceration comes in the way, and because our courts are so fully burdened, therefore, the trial gets delayed. So, keeping in mind that it is being done, and I was representing Government Union of India, Ministry of Home Affairs. Now, in dual capacity, I will be also representing the state. I had a discussion with our Chief Secretary, Home Secretary, and Honorable the CM, and they have agreed that we are going to establish exclusive special courts, particularly in NDPS cases, because so far as NIA cases are concerned, there are less in number and they will be taken care of by the existing court. So, on this aspect, we are going to respond to the Supreme Court that the state of Bihar will be progressing in on this field, and soon special exclusive courts will be assigned. Now, only the day before yesterday, I have received a notice, an order of the Honorable Supreme Court. Now, this is another important aspect. The Honorable Supreme Court, again, the bench presided by Honorable the Chief Justice, has taken cognizance and note of the fact that in our country, in judiciary, or even in the legal profession, the participation of women is much less as compared to their population. Now, the reason which has been recorded in the order is that there are no proper civil amenities for women lawyers in the district court, and therefore, the Honorable Supreme Court has taken cognizance that all the states have been made party and all the Advocate Generals have been requested to appear on this 17th July on this aspect. Today itself, I had a talk with the Honorable Chief Minister Bihar as well as the Chief Secretary, and they have said that yes, even before Supreme Court take up the issue, we will do the needful so that the women lawyers get their due, and in the district courts, we will arrange for their bar room and proper toilets. So this is another progressive steps which the Supreme Court is going to take, but Bihar will also take a lead in this. Now, I may also bring to the notice of this August House that for the purpose of speedy trial, we have planned to appoint special public prosecutors to assist the court so that there may not be unnecessary adjournment and delay in trial of serious offences. Even the e-court, the evidences through virtual mode, state is taking steps in those fields, and I think that soon we are going to have better infrastructure in the state of Bihar in judiciary. One issue, before I leave this, I want to flag for the consideration of this August House, particularly the Honorable Judges of High Court, particularly Collegium Judges and the Honorable Supreme Court here, that the system of selection of judges from the bar, there has been criticism all through on that subject. Now, I wanted to again flag this issue and remind that it is very opaque, and we have to do something to have transparent system so that not only good lawyers are selected to become judges. And on this subject, the Honorable Supreme Court judges are here. They will also, I will request them to take this call, and the judges of Patna High Court, that in future, not only that good lawyers be taken as judges, but all sections of society be given due representation. And I feel pained to discuss this, that even though in the MOP it has been mentioned that all sections of society will be duly represented, but it is in practice it is not being done. So therefore, I request the Honorable Collegium Judges and also the Honorable Judges of the Supreme Court, please take note of this fact and in future do the needful. Thank you so much.
सर का बहुत बहुत धन्यवाद। हम सभी अवगत के सुशासन की आधारशिला दूरदर्शी प्रशासन और प्रभावी क्रियान्वयन में निहित होता है। अपने अनुभव और अपने प्रेरक विचारों से हम सभी का मार्गदर्शन करने हेतु मैं आग्रह करूंगी आदरणीय मुख्य सचिव बिहार श्री प्रत्यय अमृत सर।
बिहार लोक प्रशासन एवं ग्रामीण विकास संस्थान बिपार्ड एवं बिहार जुडिशियल एकेडमी के संयुक्त तत्वाधान में आयोजित यह 2 दिवसीय कार्यशाला के मुख्य अतिथि माननीय मुख्यमंत्री बिहार
को लेकर पहुंचे हैं, क्या कहिए?
माननीय जस्टिस एन कोटेश्वर सिंह जी, माननीय जस्टिस जॉय माल्या बख्शी जी, माननीय जस्टिस मीनाक्षी मदन राय जी, ऑनरेबल द चीफ जस्टिस पटना हाई कोर्ट, माननीय न्यायाधीश राजीव रंजन प्रसाद जी, इस सभागार में उपस्थित पटना हाई कोर्ट के सभी माननीय न्यायाधीशगण, महाधिवक्ता महोदय, मेरे कलीग्स, गृह सचिव और इस हॉल में उपस्थित आप सभी प्रबुद्ध श्रोतागण, मैं सबसे पहले इस प्रयास के लिए मैं बहुत बहुत बधाई और शुभकामना देना चाहूँगा। जैसा कि गृह सचिव ने बहुत विस्तृत में बताया, he has informed the esteemed audience about the progress, the journey which we have covered in the last 2 years. मैं अपनी बात को बहुत संक्षेप में ही रखूंगा। You are sitting here, and therefore I strongly believe that the reforms, they are a continuous process. It's not a one-time exercise. और इसलिए इस तरह का जो कार्यशाला का आयोजन किया जाता है, जो फीडबैक स्टेक होल्डर्स से हम लोग प्राप्त करते हैं, that goes a long way in building this team camaraderie. The loopholes are identified because at the end of the day, जो हम लोगों का लक्ष्य है, registration of an offense to investigation, prosecution, trial, and of course the final adjudication. जो एक आम आदमी, जो सिटीजन है, उसको हम कितने कम समय में न्याय दिलाते हैं, वो लक्ष्य है। अगर हम भारत न्याय संहिता को देखें, भारतीय नागरिक सुरक्षा संहिता को देखें, भारतीय साक्ष्य अधिनियम को देखें, इसलिए ये जो 2 दिवसीय कार्यशाला है, ये एक बहुत ही सराहनीय प्रयास है। कंटिन्यूअस ट्रेनिंग, इंस्टीट्यूशनल कोऑर्डिनेशन, investment in forensic science, this is a very important area for the government, and adoption of best practices will remain essential for sustaining. ये जो हम प्रयास कर रहे हैं इस दिशा में, ये तमाम चीजें हमें लगातार करनी है। और definitely success of any new criminal law depends upon the collective commitment of each and every stakeholder. Police officers must conduct fair, impartial, and scientific investigations. This is another area which as a government we are working on, the scientific investigations. Forensics experts must provide timely and reliable scientific assistance. Prosecutors, again as a government we are working in this direction also, must present evidence effectively and responsibly. Courts must ensure fair and timely adjudication while safeguarding constitutional guarantees. So therefore, every institution which I have spoken about has an equally important role in strengthening public confidence. The key word is public confidence in the rule of law. From this platform, in the august presence of the Honorable Chief Minister, मैं विश्वास दिलाता हूं कि राज्य सरकार पूरी तरह से कमिटेड है when it comes to strengthening institutional capacity, promoting scientific investigation, expanding digital infrastructure, enhancing forensic capabilities, and definitely working in close partnership with the judiciary and all stakeholders to realize the vision of these landmark legislations. मुझे पूरी तरह से ये मुझे विश्वास है कि ये जो 2 दिन का आप लोगों का deliberations होगा, this will definitely contribute meaningfully to our shared objective of ensuring effective implementation of the new criminal laws and further strengthening the criminal justice system in the state of Bihar. बहुत बहुत धन्यवाद. जय हिंद.
सर का आभार प्रकट करते हुए अब मैं आदरणीय माननीय न्यायाधीश श्री राजीव रंजन प्रसाद, अध्यक्ष बिहार न्यायिक अकादमी एवं न्यायाधीश पटना उच्च न्यायालय से विनम्र अनुरोध करती हूं अपना मुख्य वक्तव्य प्रस्तुत कर हम सभी का मार्गदर्शन करने की असीम कृपा करें. स्वागत सर.
श्री सम्राट चौधरी जी, Honorable Chief Minister, Bihar, Honorable Mr. Justice N. Koteshwar Singh, Judge Supreme Court of India, Honorable Mr. Justice Jaymala Bagchi, Judge Supreme Court of India, Honorable Mrs. Justice Meenakshi Madan Roy, the Chief Justice of Patna High Court, Shri S. D. Sanjay, Learned Advocate General Bihar, Shri Pratyay Amrit, Chief Secretary Government of Bihar, Shri B. Rajendra, Director General BIPARD, Shri Kundan Kumar, Secretary Home Department, Government of Bihar, distinguished resource persons, Learned Registrar General, Patna High Court and the members of the registry, the Director Bihar Judicial Academy and the members of the Directorate of the Judicial Academy, Learned Principal and District Judge Gayaji, and the participating PGJs of the Bihar Just, Shri Shashank Shubhankar, District Magistrate Gayaji, Shri Sushil Kumar, Senior SP Gayaji, Government Officers of Gayaji District, Learned Judicial Officers present here and connected virtually, members of the print and electronic medias, ladies and gentlemen. A very good afternoon to the dignitaries on the dais, off the dais, and everyone present in the audience or connected through online mode. It is indeed a matter of immense pleasure and privilege to be a part of this momentous occasion. The subject matter of the two-day conference is the effective implementation of the new criminal laws through technology-enabled justice delivery and institutional coordination. The topic requires this House to discuss essentially the role of the technology and the need of institutional coordination. I would like to take the deliberation on a wider platform. What is effective implementation? How to judge the effectiveness of a criminal law, particularly a penal statute, will be a matter of discussion. Speaking from a jurisprudential perspective, it is said that effective implementation exists at the tense dynamic intersection of state power, procedural integrity, and social utility. The moment we sit to evaluate the performance of the criminal law jurisprudence, our discussion shifts from what the law says to how the law behaves. The foundational utilitarian like Cesare Beccaria, the Italian criminologist and philosopher, and Jeremy Bentham, the jurist and social reformer, point out that for the effective implementation of the criminal law system, there must be a balance among the three pillars. That is, 1, the speed, 2, severity, and 3, certainty. With the introduction of several provisions in the Bharatiya Nagrik Suraksha Sanhita, the Bharatiya Sakshya Adhiniyam, and the Bharatiya Nyaya Sanhita, we are sure that by adoption of the electronic mode of service of summons and examination of witnesses from the remote points, and by providing timelines, the legislatures have taken care of ensuring the speed. It is definitely going to help, but the speed alone cannot ensure effective implementation. The severity of punishment also plays a role. For effective implementation, the punishment must be in consonance with the status of guilt. The third pillar of the criminal law model, which Bentham talks about, is the primacy of certainty. Effective implementation depends on the certainty of the detection and conviction, not the harshness of the ultimate sentence. Here we need institutional coordination, adherence to the timeline in the matter of investigation, production of witnesses, and day-to-day trial would be important. Effective implementation requires a state of equilibrium where pursuit of substantive truth never violates procedural harshness. I am talking of the balancing of constitutional values and procedures established by law, which emphasizes on the prevention of wrongful convictions, absolute fidelity to the evidentiary standard, and protection of constitutional rights such as presumption of innocence. Roscoe Pound has in his paper titled The Limits of Effective Legal Action extensively written about the law where the law fails in practice and why law fails in practice. He was deeply concerned by the gap between the law on the books and the law in action. Through his studies, he has thrown much light on the real-world friction and human nature which constantly tests the limit of what formal law can achieve. He gives an example of 18th Amendment to the US Constitution, which banned the sale and manufacture of alcohol. Roscoe Pound found that there was an intransigence, that is a stubborn refusal to change one's views and community standards. The reality was that instead of eliminating alcohol consumption, prohibition created a massive black market. It fostered organized crime and turned ordinary citizens into lawbreakers. The case proved Pound's thesis that law cannot engineer a change in deep-seated human desires or moral choices without broad social alignment and voluntary public compliance. The 18th Amendment to the US Constitution was repealed by 21st Amendment. The second study of Roscoe Pound was with regard to digital piracy and copyright infringement, the conflict of infringing interest. It was in the context of the rise of file sharing networks and the introduction of the Digital Millennium Copyright Act. The study found that the music and film industries attempted to use aggressive litigation to sue individual internet users and shut down sharing networks. However, peer-to-peer technology evolved too quickly for courts to regulate effectively. This case demonstrates how rapid technological advancement enables subtle decentralized actions that render formal legal enforcement mechanisms largely obsolete. The third study was with respect to alienation of affections and family law, the breakdown of intimate injunctions. You cannot enforce love between the spouses. The fourth study was with respect to a public interest litigation and socio-economic rights. Here I would recall the landmark social engineering ruling by the Honorable Supreme Court of India in Olga Teles versus Mumbai Municipal Corporation, which is supposed to be a progressive ruling which recognizes the right to life, includes the right to a livelihood, ordering the state to protect pavement dwellers from arbitrary eviction. But despite the progressive ruling, executive non-compliance and a lack of municipal resources left the judgment largely unfulfilled. These four studies highlight Pound's warning that high-minded legal declarations often fall when they outspace institutional enforcement capabilities. In the 5 sessions which we are going to have during this 2-day conference, we will discuss the key features of the 3 laws and how to achieve the objective of the new laws implementation. The experts would also address on how to make effective use of ecosystem and use of the same for victim and witness communication. We have experts to address on the challenges in digital adoption. They would also let you know the solutions and how to go for the capacity building. The action plan for uniform implementation of technology adoption across the district would be required. At the end, the conference will have concluding sessions on both the days. I am fully confident that with the presence of some eloquent speakers like two eminent judges from the Honorable Supreme Court, Honorable the Chief Justice, the learned Advocate General, senior officers from the government who are holding the key position present on the dais, and the learned resource persons, we will be immensely benefited. Thank you. Jai Hind, Jai Bharat.
न्याय केवल निर्णय नहीं बल्कि समाज के विश्वास की सबसे बड़ी पूंजी है। सर का बहुत बहुत आभार प्रकट करते हुए अब मैं सादर आमंत्रित करती हूँ माननीय मुख्य न्यायाधीश पटना उच्च न्यायालय न्यायमूर्ति श्रीमती मीनाक्षी मदन राय जी को अभिभाषण प्रस्तुत करने हेतु। स्वागत मैम।
Shri Samrat Chaudhary, Honorable Chief Minister Bihar, Honorable Mr. Justice N. Koteshwar Singh, Judge, Supreme Court of India, and Ma'am Vijay Lakshmi, Honorable Mr. Justice Joymala Bakshi, Judge, Supreme Court, Honorable Mr. Justice Rajiv Ranjan Prasad, Judge cum JED 2, Patna High Court, cum Chairman, Bihar Judicial Academy, my sister and brother judges of Patna High Court, Honorable Mr. Justice Abraham Matthew, former Judge, Kerala High Court, Mr. Pratray Amrit, IAS Chief Secretary, Government of Bihar, Shri S.D. Sanjay, Learned Advocate General, Shri Kundan Kumar, Secretary, Home Department, Government of Bihar, Shri B. Rajendra, Director General of BIPAD, Gayaji, and other officers of BIPAD, Shri Balram Dubey, Law Secretary, Government of Bihar, District Magistrate, Senior SP, Divisional Commissioner, Shri Shiv Gopal Mishra, Learned Registrar General, and members of the Registry of the High Court of Patna, all resource persons, Shri Bharat Bhushan Basin, Director, Bihar Judicial Academy, and learned senior advocates, learned principal, district and sessions judges of all judgeships, and all judicial officers of the judgeships of Bihar present, senior officers of the police and prosecution, distinguished members of the bars and academia, other distinguished judges, guests present here, members of print and electronic media, ladies and gentlemen. As I welcome the Honorable Chief Justice for this program and the Honorable Judges of the Supreme Court who are with us today, their presence has surely enhanced the importance of the endeavor made by the BIPAD and the BJA to hold this conference to familiarize stakeholders with the Bharatiya Nyaya Sanhita, the Bharatiya Nagarik Suraksha Sanhita, and the Bharatiya Sakshya Adhiniyam. 25 centuries ago, on this very ground, a prince became a seeker, found enlightenment, and taught the world that a civilization is measured by compassion. A system of criminal justice, when it works as envisaged, is how a society practices that compassion, not in prayer, but in procedure. It is a society's promise that the one who is wronged will find a remedy, and the one who is the perpetrator will be heard fairly at the hands of the state. I am not inclined in these few minutes to take you through the details of various sections of the three codes. I would rather speak on the principles of why we have criminal law at all, why we have written it afresh, and why the theme of these 2 days of coordination, timelines, and technology goes to the very heart of the matter. Why do we have criminal law at all? At the bottom of it lies a very old bargain. The citizen gives up his liberty to avenge the wrong perpetrated on him, and in return, the state takes on the duty to protect his life and person and to penalize the wrongdoer. That is its genius. It takes the rawest of human urges, the urge to strike back, and hands it to the court instead. Cesare Beccaria, the 18th century Italian criminologist and philosopher, said that a penal system draws its strength not from the severity of its punishments, but from their certainty and their proportion. That is still the quiet test of any reform, ours included. Here in Bihar, in Pataliputra, Kautilya had already set it down in the Arthashastra, a science of governance in which dand, the power of the state to punish, was to be used with restraint and in measure, always in the service of nyaya, of justice. There is a fitness then in the name that the new penal code carries, the Bharatiya Nyaya Sanhita. The name itself holds an old truth of our soil, that the endeavor is towards achieving justice. Why were new criminal laws required? Because the criminal code is written for a society which is dynamic. Beneath the fixed ceiling of our constitutional morality, the content of the criminal law moves with the conscience of the people. What one generation perceives as a crime, a later one may not hold so, as our courts more often than once have shown. And there is a simpler reason besides. The codes we inherited of 1860, of 1872, and of 1973 were framed before the cell phones were conceptualized. They could not have imagined a world in which a crime is planned on a handset and its proof lies on a distant server. If crimes have moved into the digital world, the law that answers it cannot be left behind in the age of paper. So the new codes carry the law forward, and even the alteration of the name from a penal code to a Sanhita of Nyaya is more than a matter of words. While introducing the new criminal laws, the emphasis was on prioritizing offenses against the human body, against women and children, ahead of offenses against the state. That reordering speaks of something. It stipulates that the human being, and not the state, now stands at the center of the justice dispensing system. Let us examine a few illustrations. The first is access. Section 173 of the BNSS now permits a citizen to lodge a first information report at any police station wherever the offense took place, and may do so even electronically. The poor, the marginalized, and the victims of crime no longer need to know the map of jurisdictions before the law hears them. The second is a guard against frivolous complaints. Section 173(3) of the BNSS provides that for offenses carrying punishment of 3 to 7 years, the police may hold a preliminary inquiry before an FIR is even registered. In Imran Pratapgarhi versus State of Gujarat, the Supreme Court calls this a significant departure from the old law. And in Ashish Dave versus State of Rajasthan, it made the purpose plain that a preliminary inquiry is meant to prevent initiation of criminal proceedings on the basis of frivolous or speculative allegations. It shields the innocent quite as much as the victim from a prosecution that ought never to have commenced. The third is liberty, and with it, science. Section 173, in brackets 3 of the BNSS, provides that for the graver offenses, a forensic expert must now visit the scene of crime so that a case which once leaned on what an ocular witness said may rest instead on proof that can be tested on the anvil of science. Section 35(3) of BNSS mandates a notice to appear, and arrest is an exception. The Supreme Court has said as much in Satinder Kumar Antil versus CBI, by a bench which included His Lordship, Mr. Justice N. Koteswar Singh, who honors us with his presence today. It requires that the grounds of an arrest be given in writing in a language that the person can follow. Section 479, by limiting how long an under trial may be held, aims to declog the prisons, as the court put it in Kapil Wadhwan versus Central Bureau of Intelligence. Now, the fourth is the time. The oldest complaint against our courts is the perceived sloth in dispensing justice. The new procedure inserts provisions with deadlines. A charge sheet under Section 187 as a rule has to be filed within 60 days and within 90 days where the offense is punishable with death, life imprisonment, or imprisonment of death of 10 years or more. I will not dwell on the timelines which have already been spoken at length by other speakers before me. I have seen across my own years on the bench how quietly a case can grow old, and I know that a verdict that comes too late is to the person who waited for it scarcely justice at all. For the first time, our penal laws allows community service as a sentence for the smaller offenses, and acceptance that not every wrong is best met with a prison cell, and that law can set a person right without incarcerating him. Technology, which is the theme of this event, is in this conference, would dwell on how evidence is now electronic. And in an age of artificial intelligence and of deep fakes, its genuineness is doubted more easily than ever. Tools such as eSaksha and the case information system now allow evidence to be collected, sealed, and traced, and a case be followed from stage to stage in ways the draftsmen of the old codes could not have pictured. However good a law, it stays a promise on paper until someone makes it work, and no single office can make it work alone. It has to be a collective effort. The criminal justice system is judged in the end not by its provisions, but by human faces. The victim who has come for a remedy, the witness who has found the courage to speak, the accused who is owed a fair trial, the ordinary person who asks only that the law be quick, be fair, be humane, and the judge who delivers the judgment on time. I am confident that the deliberations over these 2 days, drawing as they do on the expert experience of the judiciary, the bar, the police, the prosecution, and the academia assembled here, will sharpen our understanding of both what these laws have achieved and where they still require a vigilance. With these words, I thank BIPARD and the Bihar Judicial Academy for hosting this important consultation and acknowledge with gratitude the work invested into the program by Honorable Mr. Justice Ravi Ranjan Prasad, JAD2. He has been a team leader, organized the program, drawn the cooperation of his brother and sister judges, who have all worked consistently with the assistance of members and leaders of the subcommittees to make this program the roaring success it promises to be. I also express my gratitude to all my honorable brother and sister judges of the Patna High Court who are here today to participate and also as resource persons. Your presence is a mark of your graciousness and involvement. I wish the deliberations of the next 2 days every success. Thank you. Jai Hind.
थैंक यू मैम। भारत के सर्वोच्च न्यायालय के माननीय न्यायाधीश माननीय श्री न्यायमूर्ति जॉय माल्या बागची सर का व्यक्तित्व न्याय, संवैधानिक मूल्य और विधि के शासन के प्रति अद्वितीय समर्पण का प्रतीक है। मैं अत्यंत आदर और सम्मान के साथ माननीय न्यायमूर्ति महोदय से विनम्रतापूर्वक आग्रह करूंगी प्रेरणादायी विचारों के साथ अभिभाषण प्रस्तुत करने की असीम कृपा करें। स्वागत।
The Honorable the Chief Minister, Dr. Samrat Chaudhary, my respected brother and colleague on the Supreme Court bench, Justice Koteshwar Singh, my respected sister, Dr. Vijay Lakshmi, the Chief Justice of Patna High Court, and respected sister, Justice Meenakshi Madan Rai, my loving brother, Justice Prasad, and the chairman of the Bihar Judicial Academy, the Chief Secretary of the Government of Bihar, the learned Advocate General who brings his deep knowledge of law and experience from the Supreme Court Bar, the Secretary Home Department, Bihar, the Director General of Police, Bihar, the Director General of BIPAD, Administration, Honorable brothers and sister judges of Patna High Court, the Registry and the Registrar General, Director and Judges Association, Judicial Academy, Judges, members of the Police Administration, friends, members, the resource persons who attend this two-day state consultation on the unified implementation of new criminal laws, and friends, very good afternoon to all of you. Biggest benefit of the introduction of the two criminal laws, brother Justice Prasad, is that it has given me the excuse of repeatedly coming to the state of Bihar, and particularly to my sisters and brothers of Patna High Court. Last year was the conclusion of the first year of the new introduction of the new criminal laws, and I was fortunate to be invited by the Chief Justice, Justice Virod Chandran, my respected colleague on the Supreme Court bench presently, and Justice Prasad as the chairman of Bihar Judicial Academy, for a symposium on the new criminal laws at Patna. And now, on the second anniversary of the new criminal laws, I am equally fortunate to share the dais with the highest dignitaries of the state, members of the High Court, my sisters and brother colleagues, the district judiciary, and all the pillars of criminal justice administration in reflecting on the 2-year journey of these new laws. Taking a cue from the Honorable Chief Justice, I would say 2000 years ago, Chanakya or Kautilya articulated perhaps the most important and seminal foundation of the criminal justice system when he said that a king who can fairly and justly administer punishment to his son like he would do to his enemy is blessed in this world and hereafter. The foundation of criminal justice, which Kautilya spoke 2000 years ago, 2500 years ago, finds resonance in the words of a more recent legal scholar, a former Chief Justice of the Supreme Court, Justice Venkatachalaya, when sobering the law of arrest in Joginder Kumar, the justice said, and he quoted from an American scholar, that the quality of a nation's civilization can be best measured by the method it uses in the administration of criminal law. The quality the respectability, the maturity, and the civilizational progress, friends, does not lie in economic growth. It does not lie in military power. It does not lie in state aggrandizement, but it lies in the soberness, in the effectiveness, and in the maturity with which the state administers criminal justice to uphold rule of law. It is with this vision, 2 years ago, we introduced the new criminal laws, not for mere etymological changes of name, but for change in substance. The word penal was replaced by Naya, not to change emphasis from punishment to justice, but to ensure that the criminal laws enlighten the sobriety with which we approach the idea of crime and punishment. The Bharatiya Nagarik Sanghita, which is a replacement of the Criminal Procedure Code, put the central focus not on the governance through danda or through state power, but the central focus was citizen rights. And because of the focus on citizen and not state power, the nomenclature was changed to Nagarik Sanghita and not Sarkari Sanghita. This is what the nomenclatures spoke. But more importantly, and more so after 2 years, we need to reflect, are these mere words of rhetoric, or are they really sowing the seeds of Naya, enlightening, giving effect and voice to Nagarik, or they remain a cry in wilderness? This is where I applaud the second anniversary celebration of the new criminal laws by the Bihar Judicial Academy and by BIPAD, that a 2-day consultation session has been organized for, and as the name suggests again, a unified implementation of the new criminal laws. The criminal laws as they have been drafted and created would not be a premise of one entity or one authority alone. It can't be a success if the law enforcement agencies, the prosecutors, the courts, the forensic units, and the correctional home agencies do not create a unified synergy in implementing the essence of these legislations. And to do so, what could be a better way than to reflect on what progress we have achieved in implementing these laws in the last 2 years, and what should be done immediately or should be done on a long run scale so that it can be effectively implemented in future. What would be a timeline for a clear and substantive implementation and grounding of these laws in our society and in the administration of criminal justice? The hint, friends, is given in section 173 subsection 3 of the Bharatiya Nagarik Sanghita. It speaks of a 5-year term within which the state shall make an endeavor for the purpose of ensuring a forensic assessment of every crime which is punishable with 7 years or more. 2 years we have passed. We've got 3 more years. And it is in this time frame, the legislative vision of creating an infrastructure, functional ability and knowledge, and awareness amongst people should be the goal of all the stakeholders who are entrusted with the duty of implementing these laws. How do we go about it? 2 important limbs of unity and synergy in the technical and technological field need mention, and that is also why BIPAD and Bihar Judicial Academy, in the course of the sessions that have been formulated, have insisted on its emphasis, namely the interoperable criminal justice system and the crime and criminal tracking network system, along with the e-tools which have been formulated by the e-committees of the Supreme Court and the High Courts, namely Bhashini and others. I would dwell a little on the interoperability system first. The interoperability system actually tries to create and to ensure a seamless movement of data and information between the 5 pillars on which criminal justice rests. They are namely the police, the courts, the forensic departments, hospitals, the correctional home, and the prosecution agency. The police is the first interface between people and the criminal justice system. It is at this level does the information about a crime gets reported. It is at this level the first information report gets registered and consumed into the justice delivery system. The Nagarik Sanghita creates the e-platform for consumption of information on an electronic plane. As we've heard from the Chief Secretary, that a large number of police stations have been enabled to accept the e-FIRs. But in order to ensure that the e-FIRs are really registered on a digital plane and not consumed after being registered physically, we need to have better awareness of access on an e-platform for the victim of crime. And that is where I would request the legal services authorities to ensure regular awareness programs with regard to e-registration of FIRs. A synergy at this level would require not only an architecture and functionality of consumption of e-FIRs, but robust knowledge and confidence of the people in the system. The second comes the registration, or rather the investigation of cases. And the biggest and the most significant change, as I said, was the requirement within a span of 5 years that there should be a forensic examination of crime site of offenses punishable with 7 years and more. All of us have heard about Sherlock Holmes. Has anyone heard about Sherlock Holmes of France? The French Sherlock Holmes was one who was a forensic scientist, Edward Lockhart. And the idea of trace evidence or trace element evidence was his invention. He theorized that every contact leaves a trace. That I stand here today, I have put my fingerprints on this lectern. My footprints are there. I have sat on that chair. The microscopic particles of that cloth is on my fabric. This, friends, is trace evidence. And this trace evidence, unlike oral evidence or any other evidence liable to corruption through intimidation, inducement, never changes. They remain the telltale signs of truth, which an investigator like Sherlock Holmes will trace and detect and solve a crime. That is where the foundation of forensic crime scene rests. We need to create a robust understanding of forensic science and a robust utility of forensic trace evidence in the law enforcement and police detective wing of the police administration. The general idea of police administration comes from crime control. It comes from the idea that law and rule is flowing from the stick that I hold, the danda. When society and our existence changes into from the physical world into the digital world, the danda dissolves. The danda dissolves and the electronic footprints become the vital signs for detection of crime. Today we do not require an arrest to unravel a money laundering case. What we require is to trace the way in which the electronic money transfers take place, the tracing of these lines, the placement of the ill-gotten assets, and the integration of these assets in proceeds of crime. Unfortunately, this unraveling of crime in the digital world do not require the traditional approach of physical detection, restraint on movement, and physical arrest. It requires knowledge of cryptography. It requires knowledge of a digital history of the individual who is a subject. We need, therefore, not only forensic labs in order to make 173(3) and the collection of trace evidence or investigation of sophisticated financial crimes and the like a reality. We need a change of mindset. Arrest and detention should not remain and be the first and the last word, the backbone of investigation. Investigation should rest on the idea how we can unravel hash values, break cryptograph codes, and bring to justice the wrongdoer who does not today hide in dark alleyways but remains hidden in the nebulous world of cyberspace. This mindset change is another important thing which is necessary for realization and implementation of the new criminal laws. Finally, I would end by commenting that the new criminal laws not only require a nuanced structural approach, they require support from areas which travel beyond the scope of law enforcement or justice delivery. They are the enabling forces of forensic science, understanding and development of capacity building, having a large number of persons who are able to render scientific opinion and support. In a very recent case, which I had to deal in a bench presided over with the Honorable the Chief Justice, was a question as to whether the expert of forensic, cyber law or a cyber expert must be a person who receives a certificate under 69 capital A of the Information Technology Act. Madras High Court had delivered a verdict saying 69 capital A is necessary for a person to give a certificate under 63(4) of Bharatiya Saksha Adhiniyam for admission of electronic evidence. Friends, do you know how many entities are available for giving such a certificate? It is not more than single number throughout the country. It is not more than 10. And secondly, the number of certified individuals under 69A would not exceed more than 100 as entities or individuals. In this situation, if we are to implement 63(4) and every individual, every person coming to seek justice requires a certificate from a person who is certified under 69A, we would be creating a mockery of justice. This constrained us while we upheld the constitutionality of the provision to say that the observations of the Madras High Court may not be treated as binding precedent. On the other hand, 69 capital A may be read along with 39 of the Saksha Adhiniyam, that any person who has adequate experience and knowledge of electronic law and electronics and computers, and the court is so satisfied, may be permitted to be treated as an expert like any other expert in science. So we tried to create a wider platform, and that is what we need today in order to make the effective implementation of the new criminal laws a reality. I hope and trust that in the next 3 years, we will achieve that goal. We would be able to see that the new criminal laws do not in theory become a departure from the colonial hangover in words or in nomenclature alone. They light the lamp of liberty, the confidence in the justice delivery system, and finally uphold and enlighten the rule of law for the last Indian citizen who stands in the row waiting for administration, waiting for justice to be delivered. Thank you very much. Jai Hind.
न्यायमूर्ति महोदय का बहुत बहुत आभार। और हमारे बीच भारत के सर्वोच्च न्यायालय के यशस्वी न्यायाधीश, न्यायिक गरिमा, निष्पक्षता और संवैधानिक मूल्यों के सशक्त हस्ताक्षर माननीय न्यायमूर्ति श्री एन कोटेश्वर सिंह जी की गरिमा में उपस्थिति हम सभी के लिए प्रेरणा का विषय है। मैं आपसे विनम्रता पूर्वक आग्रह करती हूँ आशीर्वचन एवं मार्गदर्शन देने की असीम कृपा करें। स्वागत सर।
Honorable Chief Minister of Bihar, Sri Samrat Chaudhary ji, इस मंच में उपस्थित, my esteemed colleague
an expert in criminal law, Justice Joymala Bagchi. Justice Meenakshi Madan Rai ji, the Honorable Chief Justice of Patna High Court, and worthy spouse, Mr. Roja, also here, sitting with my wife, Vijay Lakshmi. Honorable Justice Rajiv Ranjan Prasad ji, GAT2, Patna High Court cum Chairman Bihar Judicial Academy. श्री सत्यदर्शी संजय जी, मैंने सोचा एएसजी साहब हैं तो मुझे बहुत आनंद हुआ, यहाँ पे पता चला कि आप एडवोकेट जनरल है, बहुत बधाई हो। हमेशा रोज मिलते हैं कोर्ट में, लेकिन अलग अलग रोल पे, बहुत अच्छा लगा यहाँ आपसे मिलके। और यहाँ पे उपस्थित हैं चीफ सेक्रेटरी प्रत्यय मित्र अमृत जी और सेक्रेटरी होम डिपार्टमेंट श्री कुंदन कुमार जी और डायरेक्टर जनरल बीपार्ट के यहाँ पे बी राजेंद्र जी और ऑनरेबल जजेस पटना हाई कोर्ट के हैं ऑफ द डाइस, सीनियर एडवोकेट्स हैं और डिस्ट्रिक्ट के जजेस हैं, लॉ सेक्रेटरी भी हैं, और पुलिस के अधिकारी हैं यहाँ पे, शासन का भी, एडमिनिस्ट्रेशन का भी, एंड ऑल लेडीज एंड जेंटलमैन प्रेजेंट टुडे। बहुत बहुत आप लोग को मेरा प्रणाम, नमस्कार। इनफैक्ट मुझे बहुत खुशी हुई और आनंद की बात है कि माननीय मुख्यमंत्री जी उनके अपना बहुत समय निकाल के व्यस्त from his very busy schedule is amongst us. Why it is important is because this 2 days conference is going to be held soon after this inaugural function is not confined to the judges. We judges are mostly used to addressing judicial academies and conferences where lawyers and judges are there. But this is a very important occasion, very significant occasion, that all the important stakeholders, the judiciary हैं, वकील हैं, पुलिस के अधिकारी हैं जो इन्वेस्टिगेट करते हैं, और राज्य के अधिकारी जो इंफ्रास्ट्रक्चर को प्रोवाइड करते हैं, they are all inseparable. The discussion on these important issues, 5 topics which I have seen, cannot be complete without a cohesive, cooperative endeavor. मेरे लिए एक बहुत ये आनंद की बात है, जब 30 जून को नेशनल कॉन्फ्रेंस हुआ था बॉम्बे में, तो मुझे अवसर मिला, I had to occasion to address, also take part before the launch of this new criminal laws. And today आज 2 साल हुए, and this is a time for introspection. और ये जो जगह है आपने चुना है, बोध गया, मुझे बहुत अच्छा लगा। ये इसी पवित्र जगह पे जो सिद्धार्थ, जो राजा के एक प्रिंस था, जो एक वो बुद्ध, गौतम बुद्ध बन गए, एनलाइटन आफ्टर लॉट ऑफ इंट्रोस्पेक्शन. So this is a place where we all must gather together to introspect what has happened in the last 2 years. It was launched on the 1st of July 2024. I remember very distinctly the date when I had to attend in my own high court in Jammu and Kashmir. After coming from Bombay, I was requested by the administration that they are holding an inaugural function of this, launching of these 3 new laws. So I was there. So I vividly remember the kind of expectation we had with the launching of these 3 new laws. And what we have, therefore, today's, these 2 years down the line, where are we? What are the challenges before us? Where are the difficulties we may face, we are facing, are certainly of utmost importance to be discussed. As I stand today before you, in this country of 1.47 billion people, if you open the NJDG, abhi, just now, the figure shows 4,99,76,784 cases pending across the country, out of which 3,86,43,422 are criminal cases. The remaining 1,13,33,306 are civil cases. So it gives an idea. हमारे देश में जो न्यायपालिका है, उसमें सबसे ज्यादा क्रिमिनल केसेस का पेंडिंग है. और एक क्रिमिनल केस में एक्यूज 1 हो सकता है, 2 हो सकता है, 3 हो सकता है, 4 भी हो सकता है, ज्यादा भी हो सकता है. तो मान लीजिए 3-4 एवरेज में लोग क्रिमिनल केस में फंसे हुए हैं. लेकिन सिर्फ वो 3-4 लोगों का काम सिर्फ वही नहीं है, इन्वॉल्वमेंट. एक विटनेसेस भी हैं, वो लोग भी तो शामिल है. तो देखिए, जज और वकील और प्रोसिक्यूशन छोड़ के हमारे सिटीजन, कितने लोग सिटीजन एक केस में इन्वॉल्व हो सकता है. हम देखते हैं क्रिमिनल केसेस में 5 से कभी कभी 20, कभी कभी 100 विटनेसेस लिस्ट करते हैं. तो देखिए, 100 लोगों का एक केस में 100 लोगों का इन्वॉल्वमेंट है. जब एक केस में इन्वॉल्व होता है, कोर्ट में जाना पड़ता है, टाइम कितना वेस्ट होता है. देखिए, जो आरोपी है, एक्यूज है, तो हम समझ सकते हैं, लेकिन जो विटनेस है, गवाह है, उनको टाइम निकालना पड़ता है. तो देखिए, एक केस में, क्रिमिनल केस में, आई एम टेकिंग ए वेरी वेरी कंजर्वेटिव व्यू फिगर, 50 पीपल विल बी इन्वॉल्व. 50 people to 100 people, depending on the nature of the case. We are spending time in the court. Is it productive? No. It is not productive. We are spending, doctors, forensic experts, they are spending time in the court. They are supposed to treat the patients in the hospitals, but they have to attend the court. The productive time is wasted. The officer has to testify, Caesar witnesses. So what happens? It is a drain on the national economic sphere. Therefore, the most important thing is to ensure that our criminal justice system is efficient, speedy. That is one of the prime objective of the launching of the new 3 laws. Apart from the fact that we want to enter a new era, our constitution we had adopted in 26th of January 1950. We had made promises to ourselves that we shall secure justice, economic, political, social, ourselves. We had promised to ourselves that we'll respect the dignity of the individuals. How do you do this when so many people are involved in these court cases? Therefore, it was the need of the time, as mentioned by earlier speakers also, from that colonial mindset. We have to evolve a system which is citizen-centric. Any accused is not a subordinated person as in the past during the colonial period. We are all citizens, but somehow, somewhere, they have gone the wrong way. How to deal with our own citizens, ensuring the dignity, and to ensure that justice is given, that is the prime objective, perhaps, in my view. What propelled the government to come up with these new laws. There are others also. We are entering a new era. We are entering a digital era. That is why so much of emphasis has been given in our CRPC for going digital in investigation, also in the decision-making process. All these will be, of course, subject of discussion. How do you make the best use of this? Yes, I mentioned the figures early. The strength of democracy. There are hundreds of countries in this world. If you open the constitution of any country, every country declares itself to a democratic country. Mere declaration as a democratic does not make it a democratic country. We have to practice it. We have to believe and practice it. That's what we are trying to do it. We have a big price to pay in a democracy. There will be serious law and order issues. There will be a lot of complaints. The government is heavy-handed on others. All issues are there, but this is part of democracy. How do we make a living democracy, a functional democracy? It is also a challenge which these 3 new laws seek to reassure ourselves that we are a functional democracy. And we are trying to overcome those difficulties which a democratic country would invariably face. Unlike in many totalitarian, dictatorial society where the justice delivery system appears to be fast, smooth, efficient. Efficiency and the speed of justice delivery system does not necessarily coincide with democracy. Therefore, these are basic challenges before us. Yes, as I mentioned also, that we are entering a new era of digital science. AI has come in a big way. Fortunately, if you have read the Supreme Court, Honorable Supreme Court of India has already published the regulations for the use of AI. This is also going to play a very important role in our justice delivery system. How we incorporate, how we use the science, the developments which have taken place in digital world, how we incorporate it, how we adopt it. this is also going to play a very big role. Coming to the basic legal system, हमारा न्याय व्यवस्था जो है, I'll just narrate a very simple, I will not talk very complicated speech. एक केस होता है, any citizen feels aggrieved, his rights have been affected. He goes to the police station. What is the response of the police? There was a time police would refuse कि ये तो हमारे जुरिडिक्शन में नहीं है, जाइए. आप बेचारे जिसका जो अनपढ़ लोग हैं उसको पता नहीं, उसने देखा पुलिस स्टेशन है, चले गए और एसआई साहब ने कहा नहीं ये तो हमारे जुरिडिक्शन में, जाइए. अब कौन सा जुरिडिक्शन है, कौन सा पुलिस स्टेशन में क्या जुरिडिक्शन, उसको क्या पता. These used to be big issues. Now that has been taken care of with this zero FIR. देखिए, I mean this is what is called citizen-centric approach. Therefore, we must commend. Of course, there are issues about zero FIR. जैसे बहुत बड़े शहर में कहता है, अरे ठीक है, बिहार, यूपी, बंगाल के जो क्रॉस बॉर्डर क्राइम है उसमें जीरो FIR नॉर्मली लेते हैं, लेकिन जैसे पटना सिटी बहुत बड़ा